Yep, sign all of us. And make sure you sign all of us up. Sound good. Okay, we're going to get started here, folks, to the March 3rd, 2015 Board of Ethics of DeKalb County meeting. It's 3:35. 6:35. Dyslexia kicks up again. Anyway, welcome everyone. We obviously have a full agenda, a couple preliminary hearings, some advisory opinions, and some stuff to going forward on our discussing our office and personnel for the DeKalb County Board of Ethics. At this point, on the adoption of the agenda, I do have one item to add under board governance. I would like it to be number 1. It'd be resolution on purported fraudulent opinion. Under number 8. Number 8, resolution on purported fraudulent opinion. And everything else we move down to 2 and 3 respectfully. If anyone would take a motion to approve the agenda?
Move we approve it without addition?
Is there a second? You got a second. All those in favor of approving it, the agenda as stated, please say aye.
Aye.
Any opposed? I believe unanimous. Okay, review and approval of minutes from December 18th, 2014, our last meeting. We got these earlier. Hopefully we will. You guys see any problems?
Looks good to me.
Please review them. And once we've all read through it one more time, I'll take a motion when we get to that point.
Whatever you want it.
Yeah.
That's motion now. Hold it.
Just hold it. Some folks are doing one last. I mean, too.
Yeah, it's at home. No, you ready for the motion?
You ready?
Motion is made. Make a motion.
I'm still looking, please.
Just hold it.
Did you say some?
Yeah, there was just a typo on one page. I can't find it right now. I didn't mark it. It's not that big of a deal, so.
Okay. Approve with some mysterious typo in there that we apologize for the history. People in history. Okay.
I make a motion that the minutes be accepted.
Is there a second?
I second.
Robert seconded. All those in favor of approving the minutes as is, minus the one typo that we don't know where it is?
Aye.
Any disapproval? Unanimous. Okay. Whoops. Make sure it's. Thank you. Okay, next is reports of the financial reports. I had asked Jay Valenke of DeKalb County to come and to explain their reports and such. Unfortunately, he wasn't able to do it at this meeting. He promises me he'll be at the next one whenever we schedule it, if we have any more questions about it. But Gene and I kind of went over a little conference call with him, and Gene spoke with him a little bit more. So Gene, I turn it over to you to go over.
If you'll look at the printout that says financial report, I've attached 3 documents that Jay Vanicki provided to us. The first 2, one of them is the department expenditure report, and I've listed that as in the first column. The next one, I believe, is a general ledger inquiry with itemized payments, and that's the second report. And the third report on the very last page, I believe, is what he provided me with figures that reflect expenditures in 2015. I went through the first 2 reports and added these figures, and frankly, it didn't add up. So that's why one of the reasons we wanted Jay to come and explain his reports to us, and they are in the process of getting very detailed final reports for us. But if you'll look at the figures, there's expenditures for legal fees, a training consultant, other professional. I've put in line items for administrative and postage and copy. The total spent in the first report is reflected as $70,641. The sum in the second report is $51,767. That's quite a discrepancy, and I didn't have an explanation, and Jay is going to get us very itemized final reports to show accurate figures. But you'll see below those figures I've added in the money that the board requested that I refund to the Treasury for the county, and that leaves those 2 figures as the net of the expenditures, which was $62,641 under the first report and $43,767 under that second report. The original budget for the board was $118,000. The budget, which I believe the Board of Commissioners had held pending the board's plans for additional staffing, is that figure, $97,242. But so the total budget for the board last year was $215,242, and under either report, the budget that the board did not spend last year was $144,646 under the first report, $171,475 under the second report. Obviously, we need Jay Vanicki here to explain those figures, but I just wanted to provide the board with these figures, at least on an interim basis, to let you know kind of the ballpark of where the board was for last year. And the budget, I believe Jay Vanicki said the budget was approved yesterday. The board is approved for the same amount for 2015, which is $215,242. Any questions?
And I've been, told if if we do ramp up and go to hiring our executive director and such, that, ethics is a high priority in DeKalb County, and that if we request more money, we should be seeing it. But that, we didn't ask for any more money, because at this point we hadn't gone through or deciding what we're doing. So don't want to hold up a whole bunch of DeKalb funds pending our decisions. But I guess we've operated in a, they did increase our budget greatly. We still were conservative with our money. We didn't overspend, and we come out with a huge deficit, and hope to continue doing that.
You need a motion to approve the financial report as such as it is.
Okay, well,
Need a motion? I make a motion. Who's going
For the point of conversation, before we make a motion, with all the discrepancies here, which are pretty attention grabbing, are we sure even if we make a motion, it would just be to leave this as is unresolved until we can get is it a gentleman or a female?
Yes, gentlemen.
Until we can get the gentleman in to give us a lot more accuracy on the budget. So not a motion to approve, but a motion to wait till we can get the additional information needed.
I withdraw mine and give you a chance to make one with you.
Motion to
Sounded like
table,
yours
right?
made a lot of sense.
I would think a motion for table would be in order.
That's fine.
Whatever. I'll second that one.
All right.
He made the motion, I second.
Okay. All those in favor of tabling the financial reports until we get some more explanation from the county? All those opposed? There was none. It's unanimous. Okay. And Jean, make sure that, all right, remember if you aren't here, just get an email. Okay, we then moved on to finished business. We're going to start with the preliminary hearing of Monica Parrott against Commissioner Kathy Gannon. Is Monica Parrott or Tarrant here? I kind of wanted that to be the...
I wondered, but I had asked,
Yeah,
and
that's-
everybody said that'd be all right.
Yeah. So, since we don't have a complaint here at the time, we're going to have our investigator, Robert Brown, give an overview of what he found, and then allow Commissioner Gannon to respond to anything and go from there.
Folks, in front of you have a document there. It's rather lengthy. The last couple of pages is actually the complaint, which was filed by Ms. Parrott. And the reason we're saying Parrott and Tarrant is there's two names. One, there was an email of Tarrant. One, there was the name of Parrott. I've not been able to contact her. The phone number does not accept calls, and the email does not work. In any case, I moved forward with the complaint. The top page there is, first 3 pages is just kind of a summary of everything that happened, and some interviews that were done with, at one time, Mr. Apolinsky, who was here representing Ms. Gannon, and then also Commissioner Gannon was there at one of the interviews. I guess probably the best thing to do would just be go down and kind of open up my findings here. If you, on the first page, if you look at item 1, which was addressed in the complaint as money that was being spent, this money was spent to an attorney, Scott Bennett. Scott Bennett and Mr. Apolinsky, if I get this wrong, let me know. There was a situation in Druid Hills where a construction permit was given by the zoning board, and
A land disturbance permit was issued without a certificate of appropriateness, this being in Druid Hills, which is governed as a historic district.
right. So then there was an appeal filed, it was denied, and then you, Ms. Gannon and Mr. Rader, then hired Mr. Bennett to represent them on an appeal to Superior Court. Correct?
Correct.
Right. So that's where that money went to. That appeal was actually lost at that point, but Druid Hills is actually continuing on. They also filed an appeal, and that appeal is moving forward. So that is where that money went to. Oops. Excuse me. On gift cards, Commissioner Gannon gave out several gift cards. One was to the Scottsdale Senior Citizen, which was for a printer, the North DeKalb Senior Citizen Center, which was for a stereo. DeKalb Atlanta Senior Center was from a microwave. All these for $254.95, which was $250 for the cost of the item and a $4.95 activation fee. There was also for holiday lunches to the care homes and the DeKalb County Child Advocacy Group totaling $325. I believe there's documentation in there which supports this. While we were looking at the P-card usage, which was part of the complaint, I did notice that there was a charge on there for it said Blue Sky. And it piqued my interest in that Blue Sky is also a sporting goods store. So I inquired to Mr. Apolinski and Commissioner Gannon about that and asked what that charge was specifically. And they came back and gave documentation, which is in your package. It was part of a festival. If you want to explain it a little further, the documentation is in there.
It was a Green Commission Expo, and so it was supplies for the expo.
Right. So it was a charge for county business. And that receipt is, of course, in that package also. Office Depot, we did notice charges on the P-cards for Office Depot, which was office supplies. It's my understanding that in the county here, there's not a central supply room for office supplies. Several of the commissioners have stated that to me in some other interviews. So those P-cards are used to Office Depot to get their office equipment. So these are the issues there. Again, going on down to item 2, expenditures here for the IT services. There were several concerns in there about website maintenance, money spent for the website that Ms. Gannon had. Again, this is something that I think several commissioners have. In my interview with other commissioners, I have seen this. The best way to explain this, I think, is that the IT department in DeKalb County cannot support the commissioners in the fashion that they think is needed, apparently, to look like a professional organization. They have timely things that they want to put up on their website so that their constituents can see it. So they had to go outside to get this done and get it done in a timely manner. The director of the IT department in DeKalb County, Mr. Metelsky, I spoke to him and he confirmed this, that due to his staff, he just does not have the time to continue to do this, to try to get people and get with the commissioners in a timely fashion so they can get things onto their website. This is the need for them to go outside, spend money to get IT and maintenance on their websites. If I'm missing anything, Mr. Let me know. Let's see, item 3, there was an allegation about money being spent to Viola Davis, and that was never done, correct?
Correct.
There's nothing that says anything was ever spent to her. Park Pride, it was a donation to the organization to fund the FOP, which is the Fraternal Order of Police Groups for specific projects that were applied for and approved by the county.
Friends of Parks.
Oh, I'm sorry. I thought that was the police one. I'm sorry.
That's okay.
Do you want to explain that one a little further?
Yes, that basically there's an organization that helps promote management, beautification of parks. And so there's a system in place where you create these FOPs, Friends of Park, that are approved. They make an application, they're approved by DeKalb County. And then through this organization, they're able to get funding. And so Commissioner Gannon did provide money to support the FOP in her district, District 6, of FOPs that have been accepted and approved by DeKalb County.
Come in.
Item 4, Prism.
Okay, oh, and Prism, I'm sorry, Prism was the one that was public safety. I'm sorry, that was a donation that was given to them for their luncheon, and there is a letter in there from them stating that they appreciated the contribution by Ms. King. And then item 4, Briar Cliff Tax Allocation District. This was spent in conjunction with executive level training for them. So anything you want to add to that? I believe that's pretty self-explanatory also.
Is that all you have?
That's it. I believe, like I said, I believe everything was covered in here. There's a lot of documents, the receipts from Target, from Kroger, where these gift cards were bought, the letters in there that were sent back from the folks who received these gift cards and their appreciation for the gift cards being given.
Okay. Trustee Walensky?
Yes, ladies and gentlemen, good evening. My name is Steve Apolinski. I have the honor of representing Commissioner Gannon, and also to my left, her staff member, Michelle Waldorf. Michelle's name is scattered about this document, that the complaint that was filed. We have certainly done our best to address each and every allegation or assertion that is put in the document itself. Before touching on a couple of the matters, I would like to point out that there's a great concern about this complaint itself. As your investigators told you, he has not been able to identify this person, talk to this person. Some of these matters in the complaint go back 7, 8, 9 years. There's some question about where this information came from. Based on my investigation, Monica Parrott nor Monica Tarrant ever made an open records request. She is not known to work for the county in any capacity, and so there is some question about where this information ever came from. However, we're not afraid to address the expenditures, because by and large these expenditures were made, and they were made for proper legitimate purposes. There are some claims in here, including direct allegations of paying of kickbacks to Miss Viola Davis, who's here tonight, and I think she would reaffirm that my client, Ms. Gannon, has never made a payment to her in any form or fashion. Your investigator has done a great job of giving you an overview of the various categories. Again, you also have the supporting documentation where we go through each and every claim that is made and we address them. I do want to just supplement the record with just a couple things that I'd like to touch on. One, with regard to the P card expenditures, we've had to spend time verifying expenses as small as $4, where Michelle went across the street to make some copies. But we did that. But what is telling, and what I've provided to you, is the audit that was done here in DeKalb County, that my client, Commissioner Gannon, spearheaded the request for an independent audit of expenditures. The audit covered a 10-year period from 2004 through 2014. And what I have attached is the results of the audit with regard to Commissioner Gannon. And I'll just read into the record specifically. 99%, this relates to P card usage over a 10-year period. 99% of related transaction logs and accompanying receipts were available for review. As a whole, the district followed established policies and procedures for P card purchases. Where documentation was missing, we observed that the transaction appeared to be county business related. As a whole, we know District 6 overall compliance with established county policies and procedures. Clearly, each and every P-card expenditure has been proper and is properly accounted for, and should not merit any further investigation or ethics with regard to my client. The other matters, just touching for a minute on the attorney's fees issue. This was a piece of property in Druid Hills. It related to a permit that was issued. It is still ongoing litigation in Druid Hills itself. I've also provided to you the authority behind the blue page. There's two provisions in the Organizational Act that give a county commissioner the authority to pursue legal action where appropriate. Under 1434D2, when a variance is issued and it is alleged that the variance request did not meet the standards, activity doesn't comply with approved development and construction plans, any DeKalb official shall have the right to appeal the decision. You also have under section 27912 the power and duty of the board to hear appeals of decisions of administrative officials, and under subsection 8, appeals may be filed by any county official. And we submit that the payment to an attorney to pursue the appeal was legitimate and proper. As I understand, after hearing Ms. Gannon's matter, you'll be hearing from Commissioner Rader. Commissioner Rader also participated in the payment to Mr. Bennett to pursue the appeal. The numbers that are alleged here are inaccurate, but there was a payment. I believe about $18,000 was paid to the attorney. Commissioner Gannon paid about $9,000. Commissioner Rader paid about $9,000. Wasn't the $25,000 that's been circulated here. With regard to the IT services, item number 2, I would just point out that in the allegation, the complaint goes back to 2007-2008, that the expenditures of about $60,000 have been made over a 7 or 8 year period. We have provided to you each expenditure, each person, and what they were for. Some of these were from interns from Agnes Scott to input information. Some in the early years was the hosting of the website. Some is to people that update the website. Commissioner Gannon is one of 2 super district commissioners here in DeKalb County. She represents the western half of DeKalb County. Her constituency is over 350,000 people. I think looking at these numbers, it's very reasonable that these expenditures were made, and there's certainly no ethics violation with regard to the expenditures. The third item, again, which are alleged to be kickbacks and payoffs, again, I'm just going to say that there's no merit to the allegations that are put forth here, and they should summarily be dismissed. And then finally, with regard to item 4, these are monies for planning and education. And again, we provide the supporting documentation to show that this involves going to conferences and education in furtherance of Commissioner Gannon's responsibilities as a commissioner. Kathy Gannon has served as a DeKalb County Commissioner for over 10 years. I'm honored to say I've known her longer than that, and she has a stellar reputation. We certainly are happy to address any claims that are made, but these are completely without merit. And for that reason, we do ask that the complaint be dismissed. Thank you.
Okay. Any questions from the board? Anyone? I want to.
Yes, one question for Mr. Browning. I was hoping he could, I know he did an overview, but I would want to just hear him conclude your thoughts on the completion of the investigation.
Well, again, like I said in the report there, I haven't found anything that they could not justify. They were very forthcoming with any information. Me and Mr. Apolinsky met twice. Once, as I said, with Commissioner Rader. We have spoken on the phone several times. I feel as though I could not find anything that showed to me that she had violated any of the ethics code.
I just had a question, and I'm not sure if I heard you right, but you said something about both commissioners paid about $9,000 each, not the 25 that was alleged.
Yes, ma'am.
And that, do you have records? Or do you have anything to verify that?
We have supporting documentation. I believe it's been provided. I don't think there's any, I think so. I don't think there's any dispute that Attorney Bennett was paid about $18,000. In the complaint, it's alleged that my client paid him $18,000, and correcting for the record, she paid half his bill. The other half was paid by Commissioner Rader, who will also be up here and can certainly address any questions that you have. But she paid the bill in furtherance of this matter in Druid Hills. It's a piece of property, and it's a whole story into itself. It'll probably be going on for years to come.
And yes, ma'am, I did speak to Scott Bennett, and I don't remember the exact amount, but I really wasn't concerned about the amount. I think my concern was whether or not they had the right to be doing that, and I believe they do. Everything that I have found, even Scott Bennett noted DeKalb County Codes 27-912, which I think Mr. Appolinsky addressed. So
Right.
I believe that was.
And so along those lines as well, I think I understand it the same way everyone else does. And but what I would like to know is, what is the criteria that a county official would use or used in a sense in that matter to determine which appeals you'll get involved in?
Well, in this, what we have to really look at is on a case-by-case basis as opposed to a general. It's a good question that probably would take more time than we have. What I would ask is that you focus on this particular matter, this particular situation, which involved a piece of property in Druid Hills. Druid Hills is a historic district. There's a little bit of deja vu. I was here 6 months ago with my wife on the historic preservation. And so there's some issue about a permit being issued without a certificate of appropriateness. And so it's a valid issue to be addressed through the courts. And so it was a valid purpose to pay a lawyer to file the appeal.
Right, and I'm not questioning that at all. I think what I'm saying is kind of going forward and making bad laws, setting precedents. What happens if a citizen wants you to get involved in another appeal?
I've been
you say you
involved
don't-
in 2 appeals during my 10 years, and they were serious, and what I determined to be a serious, blatant mistake on the part of the administrative official who went forward with a decision that clearly affected a large group of people and set a very bad precedent. And so it's a high standard that I look at, and I've only done it twice in my 10 years.
Anyone else have any questions? I guess on the commissioner website, I just want to make sure there was nothing political on that website. The website was purely of
It was just
government.
expenditures, just expenditures to.
And y'all certainly are welcome to go to my website, www.kathygannon.com.
Yeah, nothing. It was all having to do with county business. It was just the expenditure itself that was somebody had questioned. Why were they spending money outside the county when they have an IT department within the county? But I think we addressed that, where even the director of the IT department says he cannot keep up in a timely manner. So to look professional, I think it was well within their right to do that.
Anyone have any other questions? And if not, we can kind of start discussing amongst ourselves. We obviously can ask questions again if something comes up. Does anyone have a particular, initial thought on this?
Well, we sort of lack any probable cause here. And it would be my inclination to move in that direction, to dismiss it for lack of probable cause.
Robert?
Well, I read it early today, I'm just getting it for the second time. But if we want a second that motion, I'm all for it.
Well, I just want, let me have everyone discuss, I just want to make sure. Edwin,
Based on all the information that's been presented to us, and it being factual information, I'm including the audit from the county as well as the investigator as well as the attorney and Commissioner Gannon at this time, and missing the person that has filed this complaint. I would concur with Susan that there's really no room to proceed. The case has been made, and so at this point, I'm okay with making a decision to move forward with dismissing.
Claire?
This is, the situation is quite similar to Commissioner Johnson. And I think that we should have a discussion, the board, about what we move forward on and what we stop at the beginning of it. There's a lot of money has been spent just to prove that a person was operating within the scope of their office. And, you know, they get a budget and there are no real restrictions on it other than, you know, to be ethical and proper in their expenditures. And I just think that every time someone doesn't understand what the commissioners are doing or doesn't understand the process, I don't think that a whole lot of money needs to be put into trying to clear somebody's name and clear the process. It's bordering on ridiculousness. And you know, I think that we are going to have to stop having a knee-jerk reaction to the knee-jerk reaction. You know, there's not even a hint here. And so I moved for dismissal.
Okay. I also agree that there's not a hint of any ethical violations. I believe while I you know, don't want to willy-nilly waste our county resources to disprove, I think it gives both the public that there was a full and complete hearing on this matter, that it was fully investigated, that there can be no question that there was something unseen. Everything has come out. It is a long process, but I believe allows Commissioner Johnson last time, and I believe Commissioner Gannon at this time, the opportunity to say with complete truth and honesty that everything was looked at in the complaint and it was completely gone, and that I acted in an ethical manner. So
I just have one comment. It just takes too long to get this done. You know, people that's out there hung out on the rim and all kinds of nonsense is written about them. And we need to do this. If it comes before us, do it, get it out the way, and let them go. I think we've been dealing with this for a couple of months.
Just a couple of months, right? Since the first of the year, basically.
yeah, but in the
I
first
know
year.
Larry Johnson, we dealt with that for 6 months. Yeah, that's the thing that bothers me about this.
And we're, as in the last 2 meetings, we're getting these cases put in front of us and move on.
Move on.
Yep.
That's it.
So I think we've all stated kind of where we're going with it, so I'll take a motion.
Claire already made one.
Claire made the motion.
Claire made the motion to dismiss for lack of
Did you
probable
second
cause.
it?
Is there?
No, I didn't. You can though.
Well, I'll
You're
second it.
big on
I don't have a
second.
problem with second.
Right there in second. I will take your second.
No problem.
All of those in favor of dismissing this case against Kathy Gannon for lack of probable cause, signify by saying aye.
All right.
Aye. Any opposed? That was you were an aye, correct?
Yeah, I was an aye.
Okay. Unanimous.
I would just ask one point of clarification, that it also be dismissed as to Michelle Waldorf. And that she's mentioned
No doubt about
in the complaint itself as well.
Claire, you want to?
So moved.
So, okay. Second, and she's added.
Proud of you.
Thank you.
We don't want to leave without letting Commissioner Gannon know we really appreciate the service you provide for DeKalb County. And if there's any way we can say this to you, it would be simple. We apologize, but we have to let the law take its course.
I certainly understand, and thank you for your service.
Thank you.
Yes, second one. Okay. We have the next hearing of Warren Mosby against Commissioner Jeff Rader.
Mr. Chair?
Yep.
Before this starts, let me just say that as a member of the Board of Ethics, in his consideration of the complaint by Howard Mosby against Commissioner Rader, that Jeff Rader and I worked together at the Atlanta Chamber of Commerce for a number of years, and while I believe that I can render an impartial and unbiased opinion based on the evidence, out of an abundance of caution, I wish to avoid even the perception of a potential conflict, and as a result, I'm going to have to recuse myself on this matter. And there is a second matter on our agenda tonight, a Barbara Lee against Jeff Rader. So on both of those matters, I will recuse myself. And for the moment, I'm going to, while you hear the case, I'm going to just step aside.
Okay, thank you very much.
And bring the coffee, though.
Okay, this is the case of Warren Mosby against Commissioner Jeff Rader. We're going to first hear from the complainant, then the defendant, and then we'll hear from our investigator. And that's how we're going to handle it. So, Mr. Mosby, if you would. Thank you, Jason.
Thank you. Esteemed board, I thank you guys for giving me this opportunity to present my concerns before you. And I do appreciate all of the service that you guys sacrificially give to us, the citizens of DeKalb County, and that you do go through this process, which is sometimes very painful, but I think it is a necessary function of our justice system to do so. So I appreciate the work that you guys do. And I appreciate the work that our Board of Commissioners do as well. They are sometimes volunteers because they serve a whole lot more than what we definitely compensate them for. But in this matter, I'm here asking this esteemed board to fully and completely examine my allegations against Commissioner Jeff Rader through the calling for a formal hearing of these charges regarding Mr. Rader's violation of the disclosure requirements of the Ethics Code and his improper use of his county budget to inappropriately benefit himself and other special interests. The 5 areas or acts that I describe in my complaint show Mr. Rader's continual contempt for the integrity and ethics in the execution of his office as commissioner, and that those actions have had the impact of greatly harming public confidence in the impartiality of DeKalb County's governing authority. And being revealed through your investigation, hearing, and thoughtful consideration, you will then be provided the opportunity to address these alleged infractions in the manner that you deem appropriate and in accordance with law to additionally render justice for the people of DeKalb County. And the most critical of these acts is the first one, wherein Mr. Rader is alleged to have violated the dictates of the Ethics Code of DeKalb County while hiding behind a thinly structured request for an advisory opinion from this board. The opinion, which Commissioner Rader complied with, only addresses the need for Commissioner Rader to not vote on issues related to his admitted employer, Jacobs Engineering, which would clearly be a violation of ethical behavior. However, Commissioner Rader did not ask this board to be excused from the Ethics Code Section 22A, paragraph D, which states that if a conflict exists, it must be disclosed at each and every instance of the conflict. The intention of the law and the need for this level of transparency is clear. We're considering, say, 4 years after the initial disclosure and advisory position. The public then observing the commission has no idea that a member of the commission has a financial interest in the act of the commission that's being considered. It is not the intention of the instance of an advisory opinion to relieve the member of the governing authority from a disclosure of the conflict of interest continually present whenever it arises. I would even suspect that a blanket opinion regarding such an obvious continual conflict of interest would be considered to be counter to the intents and goals of the legislature through its development of our ethics code, which is echoed in the preamble to the code, section 22A Section 8, paragraph 1, which states, "It is essential to the proper administration and operation of the DeKalb County government that the members of its governing authority be and give the appearance of being independent and impartial, that public office not be used for private gain, and that there be public confidence in the integrity of the DeKalb County governing authority. Because of the attainment of one or more of these ends is impaired whenever there exists in fact or appears to exist a conflict between the private interest and public responsibilities of members of the DeKalb County governing authority, the public interest requires that the General Assembly protect against such conflicts of interest by establishing by law appropriate ethical standards with respect to the conduct of the members of the governing authority in situations where conflict may exist." This board has the responsibility, and the Ethics Board has the responsibility and opportunity to correct this oversight and require Mr. Rader's compliance to the intent and the spirit of the law, not sanction Mr. Rader's slick way to avoid it. Mr. Rader knew of the limitations of this opinion and its shortfalls, and he exploited them. I believe that there are instances where Mr. Rader used his influence with the governing authority to position Jacobs and its employees favorably to increase their chances of winning business with the county. Clearly, Mr. Rader had no intention of distancing himself from assisting Jacobs Engineering in achieving its business and contract goals in DeKalb County, and relied on your advisory opinion to mask his unethical behavior. Board members, it should not be allowed to be so. Through a formal hearing before the board and with other commissioners and staff called in to testify, I believe it will be shown that Mr. Rader continually worked to influence the governing authority and their subsequent votes on behalf of Jacob Engineering and its partners, that the members of the governing authority and staff were led by Mr. Rader to believe that they could rely on your advisory opinion. This reliance was intended to cover his known violation of the intent of the Ethics Code. It is right for him to bear the responsibility for his contempt and ignoring of the ethics law in their essence, thereby taking advantage of them and the employees of DeKalb County to enrich himself for many years. The matters of the P-card misuse by Commissioner Rader, the hiding of expenses through invoicing such as AT&T personal phone bill that he had, unusual payments to attorneys for undisclosed matters, his unauthorized and unsanctioned trip to Istanbul, Turkey for some undisclosed reason, and his paying of trips to events and memberships to organizations that are directly related to his field of employment, planning, are together indicative of his disdain and avoidance of the intents and directions of the Ethics Code of DeKalb County, and the facts, testimony, and his own pleadings must be considered further by this board, or our ability to have confidence in DeKalb's governing authority's integrity will be greatly impaired. I am respectfully asking that you move this complaint to full hearing and allow for the facts to be explored in detail. If Mr. Rader is innocent of wrongdoing, this is the best way to ensure the people of DeKalb of the state of his true nature and intentions in these matters, while providing DeKalb the insurance that leads to continuing trust of their governing authority, which is the very essence of our ethics code. I want to thank you all for considering my request and for your service on this board.
Commissioner Rader.
Thank you all for being here tonight and for your service. First, I'd like to draw your attention to the fact that this is a preliminary hearing and therefore is intended to require the show of probable cause. Nothing that Mr. Mosby has said is any evidence. It's all assertion. There is no evidence in what he's presented today, and there is no evidence in his complaint of the allegations that he makes. He references Ethics Advisory Opinion number 9, which I think that you have a copy of. That advisory opinion was requested in 2007, just after I came on to the Board of Commissioners, and stated the nature of the potential ethical conflict that I was seeking guidance on. That ethical conflict did not change in any matter until throughout my entire tenure of employment and service and coincident service on the board. In other words, I was a professional employee of Jacobs Engineering. I had no responsibility for profit and loss. nor did I own any stock in the company that would be enriched as a result of the company's performance. And so the nature of my ethical conflict did not change at any point. The request indicates the nature of business that Jacobs would compete for, and that was consistent with their conduct of business during the entire time of my employment. Mr. Mosby does not present eitherwise any evidence that I did not fully disclose and recuse myself from voting and absent myself from discussion or any of the other activities that I was required to do as a result of the advisory opinion. So in spite of the hyperbole and the frankly virulent accusations that he makes, he presents no evidence in support of his claims. And this hearing is intended to provide you with evidence that would take you further to a full hearing. And without evidence, I hope that you will consider dismissing this claim against me. There are other complaints in the ethics complaint against me that basically are complaints against the Board of Ethics, saying that the Board of Ethics improperly relieved me of responsibility to address what he considers to be an inherent conflict. Again, there's no evidence that that is the case, and this is an evidentiary hearing. As it relates to response to Act 2, there was an investigation done. I used the cell phone in question, or used it, in order to maintain a number that was generally accessible and well known to the public. And we maintained all of the records of that phone. There is no allegation that the records were not available for review. And to my knowledge, no request for those records has been made. The charges aren't unusual, nor are they in any way lumpy. There's no spikes in charges or anything like that, and there's no policy that prohibits that expense. The county audit that is attached does not find fault in that practice. As it relates to the allegation in my membership in the Georgia Planning Association, I would suggest to you that comprehensive and land use planning is an essential enumerated responsibility of the Board of Commissioners, and that certainly any expenses contributing to expertise in that subject matter provides direct, important benefits to DeKalb County and the constituents that we serve. Membership in this organization is not required in my profession. It's not a license, and to be a member is not required in order for me to do business. Nor does anything that I do tout that affiliation, and it's not an employment-related expense. The assertion or allegation related to travel to planning conferences, again, there is substantive information that is directly useful in the conduct of my responsibilities as a planner, as a commissioner in the planning field, that are obtained at those conferences. Moreover, I represent planning officials on the board of the Georgia Planning Association. So by representing elected planning officials on that board, I'm able to advance the interests of local governments within that venue, and to influence state policy in the interest of DeKalb County in that role, delivering, again, substantial benefits to the people of DeKalb. Let's see, under, okay. Let's see, the final element of that is an inherent conflict of interest between my commission duties and the employment. Again, that's I think that is a fault that is alleged against the Ethics Board. On Act 3, the issue of travel, I've provided documentation of the invitation to the trip sponsored by the Istanbul Center, which was attended by elected officials and state economic development officials. You can see it as an itinerary. It shows direct business development type activity. At the time, Turkey was one of the top trading partners with Georgia, and certainly being able to bring that type of business and build on those relationships in hopes of landing businesses here is a relevant and direct interest of every member of the Board of Commissioners and governing authority, and is not an unusual activity as evidenced by the presence of other elected officials on that trip. The only expense incurred was an expense for airfare, and the rest of the expenses for the trip were paid by the sponsoring organization. Even today, I'm still active with this Istanbul Chamber, the Turkish American Chamber of Commerce, and other Turkish entities, again, trying to build the potential for business development and economic development in DeKalb associated with that relationship. Let's see, P-card for personal purchases. I would refer you to the audit of the P-cards, where I likewise have been found to be in compliance. I think the only exceptions were beyond the county's document retention deadline of 7 years in the past, and those expenses, were noted, and the document retention policies limitations were likewise presented in that audit, which was a clean audit. County expense accounts for expenditures for what is characterized as the Southeast Energy Institute. I believe that is the South Face Energy Institute, and I've provided documentation of that expenditure that is captioned Zoning Proposal Review. There is also a scope of work that is attached to that clearly documents that this was to develop conditions to advance low-impact development techniques on a sensitive piece of property that were incorporated into the zoning conditions to the benefit of the county and its residents. And so this was a direct expenditure in line with my responsibilities as a commissioner. The improper use, Act 4 of my commission budget for influencing, this goes to these legal fees, Mr. Bennett, and then another expenditure. Within the context of Mr. Bennett, you've heard the explanation for that expenditure. The only amplification I would make is that we were challenging a decision by the administration. And so our first recourse is to go to the county attorney and ask them to represent us in an action. But where the county attorney is also representing another part of the governing authority, they have a conflict of interest. They can't represent both sides. And so to the extent that the county attorney's office was defending the action of the administration in awarding this land disturbance permit, they could not likewise represent we who were challenging that. And as a consequence, we sought and received authorization from the county attorney for incurring that expense, and I think that Mr. Browning's report has documentation of that consultation with the county attorney on doing that. As it relates to the expense with Turkheimer and Haddon, the purpose of that was to investigate the potential misuse of county staff and county resources by an elected official. Again, by virtue of the fact that there is a conflict within the context of one member of the governing authority against the other, we had to go outside of the county to ascertain that, and were able to ascertain particular facts that were then referred to the district attorney, who has told us that there is an ongoing investigation of those particular facts and that is as yet unconcluded. Let's see, Act 5, expenses outside normal duties of the commission, $2,500 to North Lake Community Alliance. North Lake Community Alliance is a community group that has competed for and won regional funds to improve streetscapes and other activities in the North Lake area. This was in support of that community collaborative between the business community and the neighborhoods in that area. Again, an organization that delivered direct services to DeKalb County constituents. This issue of the computer expenses, you've heard the explanation that based upon workload and the immediacy of response, it is the practice of the commission that is confirmed by our IT department that those are expenditures that are appropriate in service of our public responsibilities. And I won't belabor that particular issue. And again, I would remind you that this hearing is to not only present facts related to where expenditures went, but also evidence of how those expenditures or those acts were violations of the ethics code. The only evidence that has been presented in this case is my letter of response and the initial complaint. And so I would suggest to you that there is nothing in the complaint that proves the allegations, and that there is a great deal of useful information in the response to explain those as legitimate county expenses.
Robert?
Yes. Just before we get started, I do want to make, on page 2, item 3, I believe it's paragraph 4, I inadvertently put in there that South Face regarding, charges were to South Face regarding training. That was a misprint on my part. I should say a zoning review, but you do have the documentation that Mr. Rader provided to us. Just wanted to get that on record before I forgot. Again, on item 1, it does go to appear to be a problem there because there was an opinion given by the ethics board about Mr. Rader's duty to disclose his relationship with Jacobs Engineering. So I think that would be something that we would have to address. I don't know. I think Mr. Rader did all that he could do based on the opinion that he got from the board when he would disclose his relationship with them when anything came up to the commission. So I did not pull records on that yet. It would be lengthy to do that, but I believe that would be a question for you to take under consideration. With regards to item 2 and the cell phone, you heard Mr. Rader's response on that. This cell phone was one that he had been using for a number of years, had his contacts in it. When he became a commissioner, he continued to use that and pay that out of his budget. That has been since corrected. He's got a number now that is his county phone, and it does roll to his county phone, and he is using his county phone now and paying for his personal cell phone out of his pocket. During our interview, I did use my own phone and called the numbers, and it was correct that it did roll. So that is for sure doing that. Item 3, the trip to Turkey. I think he explained that very well. You do have the documentation in there. All of his, the only charge that he had was just his airfare. Everything else was provided by them. So, do you have a question, Robert? I'm sorry.
Well, I got one. You go ahead and finish that.
Sure. Other expenditures that were listed in here, Cafe Lily, that's in conjunction with normal business activities, just a restaurant here in town. I think everybody might be familiar with that. Gas to the QT, contribution to Thanks Mom and Dad, and then of course the South Face regarding training, but that should have been for a zoning review. Item 4, we spoke about that already with Commissioner Gannon. Scott Bennett was employed to do that appeal for them. We've already discussed that. It was listed in there underneath that one as Turkheimer and Hayden were also employed, involved in that initial appeal. That is not correct. In an interview with Mr. Rader, he further explained why Turkheimer and Hayden were employed. There was apparently an allegation that another commissioner used on-duty staff to help conduct a fundraiser, which turned out to be a political fundraiser. At least that is the allegation. There was a golf tournament. I believe Commissioner Rader and Commissioner Gannon wanted some direction on that. They went outside, hired Turkheimer and Haddon to get an opinion on that. Once that opinion was received, they then contacted the DA's office, Mr. James, to see if he would not look into the matter. I have spoken to Mr. James. He did confirm that his office is looking into it, but he stopped short of calling it an official investigation at this point. And that was all he had to say on that. Again, these other items here that Commissioner Rader has already addressed, the North Lake Community Alliance, IT services, we've already spoken about that, why they go outside. Again, Mr. Metelsky says that they cannot handle the volume that they need. The other folks there, Heather Fleury, who's also part of that IT department, or excuse me, IT expenditure, where she was working on website maintenance for them.
That's it.
Okay, the questions for anyone out there? Robert, yes.
I have a question for Commissioner Rader. The turkey trip, how did that help DeKalb County in any way? Maybe you could explain to me what was the trip really about DeKalb County? It was about the state of Georgia.
Well, it wasn't necessarily, I mean, obviously, I was there on behalf of DeKalb County.
Okay.
I shared with people the advantages of DeKalb County, our multicultural society here, the fact that people from many areas of the world have found a home in DeKalb and are successful in business here, and highlighted DeKalb as a potential target for where they're going. So when I talked about the United States, I didn't talk about, Savannah, I didn't talk about Columbus. I talked about how DeKalb was the place to be and to do business in this area. Moreover, several members of the DeKalb County delegation were likewise on that trip, and we all were promoting DeKalb as a location. And you will see through the agenda here that there were numerous opportunities to contact. Moreover, I traveled in my capacity as a DeKalb County Commissioner and would not have been on this trip if it weren't for the express purpose of building those relationships as a Commissioner.
Did we have any success on getting business in the county?
We have had some other, I've had people come as a result of this and recontact. We have businesses that are located here. Can I say conclusively that they wouldn't have located if I had not gone? No, that's not the nature of economic development. It is a wide bundle of things that ultimately results in a location. There are relationships, there is, business matters, there are logistical issues. All of those combine to do that. And so you can't ever put your finger on one thing. But I would suggest to you that this is a practice that is, widely practiced in government, and that this is a matter of course within, local government.
Just one quick question. I note that, for example, with Commissioner Gannon, we were able to see the outcome of the audit. What was your percentage on accountability?
I don't have it in front of me. I think it's right there. It's in, the high 90s, something like that.
But it's not in this report, though, is it?
Pardon me?
I don't think, I did not put a copy of that in.
Okay.
I just addressed the concerns that.
Okay.
I
was just curious.
attached it with my letter.
Okay. Oh, you did?
Yeah,
I'm sorry.
I might not have put it in there, but it was.
Okay.
Yeah, but I do have a copy of that. I can get that.
All right.
It was-
High 90s.
Addressed it to you. Yeah.
Yes, it was very high, and there was no concerns of compliance within that
Okay,
report.
thank
so,
you.
Right.
May I respond to some of the comments that Commissioner Rader said? Is that proper?
I object.
Now, right now, we're asking questions, and then we'll see where from there. Claire?
Just a little bit, clarification on the phone. Who is Miss Enlow?
Oh, Caroline Enlow, she also is my assistant.
Oh, okay. And you both were saying that you got an approval from the IT for you to use that personal cell as your county cell. Did you not have a county cell at that time?
That's right, no county cells.
Okay.
Robert, was there, in either through conversation with Mr. Mosby or Mr. Rader or any investigation you did, have any reports of facts of Commissioner Rader moving business or discussing business, Jacob business amongst during his time?
No, there were no specific incidents that Mr. Mosby gave me. As again, I did not pull a lot of the minutes from any of those meetings. I wouldn't even have. I'd have to go back and research that and find which meetings that actually occurred in. Mr. Rader is quite sure that he did everything he was supposed to do about disclosing his association with Jacobs Engineering. I don't have any documentation at this point, but again, Mr. Mosby did not give me any specific dates or times for any incidents where that actually occurred. That would be something I would have to thoroughly research.
Didn't we have a meeting before about Jacob's ethics last year?
Yes, that was dismissed.
That was dismissed? I know that part. I'm trying to figure that was just a few months ago.
That's right. Very similar allegation.
So I'm a little bit confused. You asked, what was your question?
Well, I mean, there was an insinuation that there was like a outside of the actual meetings that there was some pressure given to Jacobs Engineering to pressure business one way or the other. And I was asking if we have seen any evidence of that, if we have any documentation or evidence of it.
Okay, I understood Mr. Mosley's complaint to be that he did not disclose his affiliation each time Jacobs came up for a vote.
That's correct.
Okay. Well, on that matter, I guess the ethics opinion is designed to address the overall situation. It would be somewhat unreasonable to require an opinion, a study of the matter each time the situation arose.
And that would not be required under the ethics code. The ethics code talks of disclosure. And it's a simple matter. It's just disclosing. I have a conflict of interest, and I'm just making this public on this particular matter coming before the commission. The onus is on the member of the governing authority, not the public or the board of ethics, to make that disclosure. It is, as Mr. Brown had said, it would be very difficult for them to find it because there might have been 20 or 30 instances over thousands of acts that the commission took.
Well, when you say make that disclosure, I'm not sure I understand what you mean. Should he have made the disclosure at each meeting?
At the meeting where a matter concerning Jacobs was being considered. Just
I
that
thought his
matter.
opinion only said that he can't participate in any votes concerning Jacobs.
I think that's what we voted on the last time.
Right. And moreover, I did that. When there was a vote.
Well, and let me hold on.
Right.
I mean, you've alleged that there was non-disclosure. When was there non-disclosure?
At those meetings where Jacobs matters were taken up with the commission.
Where's the evidence?
Yeah, when was that?
there were many opportunities. I didn't know the depth of Mr. Brown's investigation. That's why I asked the matter to move to a formal hearing. We can get that information from the clerk of the commission. And Mr. Rader can testify as to whether or not he did in fact do that in those instances. But it is a massive work to pull those records and get it done. At this particular hearing is the matter of the depth of the evidential hearing. In presenting the fact that he had the relationship, that the ethics code in fact asked for that to take place, then he can testify now if he did it or not. And I think that would be fine for the board to consider. To have us do the technical aspect of going in and pulling all of the information to show you that he didn't do it would in fact elevate this to the formal hearing. And so I think sufficient ground has been set there that any further inquiry through a hearing process would be applicable. And if I could, I would like to indulge the board to speak to the matter that has been talked about concerning the hiring of attorneys. As a citizen, I don't think it appropriate for my county government to sue itself. I think the organizational act that gives standing to commissioners to bring action against the county is just that. It gives them standing to do so, but it doesn't authorize them to spend county monies to do so. And that is where Commissioner Rader, I believe, has violated ethics laws to use county monies out of his budget to then become actually part of administration or part of the operational function instead of the legislation function, becomes part of the executive function and determines unilaterally to exercise a legal action against the commission.
Okay, Mr. Chairman, is this going to be a conversation?
No,
or-
there was a question asked, and
Right,
we're not
but then
going
you sort of,
to, no, we're not going to get into.
right, you sort of bootstrap this other
Well, I mean,
expansion.
so, is
Can
there
I
anyone
respond
else?
to that? Is that the
I
whole
would like to,
Sure.
have a
If you'd
question
like.
answered, yeah.
Sure.
Is there any other questions that we have in?
Well, I guess I'm still a little bit confused about the disclosure part, because
I'm hearing what you're saying. I wonder if that's something we should discuss when we go into, when we're discussing after.
Yeah.
Anyone else have any more questions? Okay, I'm gonna, if no more questions, let's kind of discuss this right now. As far as what you're saying, Clara, about the disclosure part, we're not getting any evidence of that there was any non-disclosure. I think we're being asked, are we not being asked to figure out when the disclosure wasn't occurred, and we had to go, it seems like to me
Well, I
that.
think the disclosure was when he came to the ethics board and asked and said, there may be a conflict, give me an opinion on it. That was the disclosure.
And then, of course, if there would be a point where he didn't recuse himself that would be a different matter.
That would be a different matter.
But we don't have that here, that I'm seeing. Because, if there was a point in which there was evidence showing that there was some kind of facts that any business was moved to Jacobs Engineering by Commissioner Rader,
Right.
or a vote that was taken that he didn't recuse himself, or a vote against a competition in which he voted no, and then Jacobs Engineering got the contract or subsequently even bid, that would be something that,
Right.
shows some kind of ethical violation.
In my mind, yes.
Yeah. Let's see.
Just want to take an opportunity to say that our decisions are made on evidence and not the grounds.
Correct.
That was emphasized. And where that becomes important to us is we're now again being set to investigate without probable cause to, how do I say this? We now will end up having to do the work.
Well, basically, it's called a fishing expedition.
That's it.
Without
All of those
without
syllables.
specific dates.
Yes, we would have to do the exposition, is that right?
Yep.
All right. And so it links to what Claire said earlier. We have to take some control on expenses, not only for individuals, but for the board as well.
and I would say, if during our investigation, there's communication between an investigator and the complainant about specific facts that would have given rise to some kind of violation out there. Vis-a-vis the disclosure part, there would have been money spent that we would have found that we could have moved that to a final hearing. I'm not seeing that in the evidence. The last matter that was brought up kind of on the end, I kind of find that to be more of in terms of whether or not the commissioners can sue the county. That's, to me, seems to be a legal question, not necessarily an ethical question, and also a political question.
Well, and one that we would need an opinion from the county attorney, but the law clearly says that they have the right to bring suit.
Yeah.
So I don't know that this is the forum for discussing the wheres and the rights and the wrongs of that. I get you. I see your point, but we're not the right forum for that, and the county attorney would need to give us an opinion.
Now we're just started discussing. Where the cell phone, I guess, it was, personal use. It was his personal phone he was using for county business. It was starting to be paid by the county. It looks like there was a policy change, and they changed the way they did that. It seems like it was kind of a county policy.
Right, and there was no other phone.
Yeah.
So it wasn't like there were two phones.
Yep. If we go back to the website, it's the same as last. And I guess there's no evidence of any political campaign stuff on the website. That's used for county business. We did have questions about Turkey. What's your, anyone want to comment about the Turkey trip?
I think it's well explained here.
I think I asked all the questions I need on the turkey trip.
Okay. I just want to make sure we went over all the different allegations
Yes.
that are there. And then the attorneys for the zoning issue has been talked about. Does anyone have any questions about that, or want to talk about that? And then the other one about the golf tournament fundraiser question. Anyone want to talk about that? Well, Claire, what are you thinking?
Oh, well, then if no one has anything else to add, I move that we dismiss. Move for dismissal.
Okay.
Based on a lack of probable cause.
Okay.
Were you finished, Robert?
Yeah, I'm dead. I'm ready to vote.
She made a motion.
I thought maybe you were gonna say.
Okay.
I was just waiting on you.
It doesn't take all your.
Go right ahead, Rob.
I don't want to get ahead of you.
That's right.
Delane, will you please repeat your motion?
Motion to dismiss based on failure to establish probable cause.
I second.
Okay. Anyone want to discuss? If not, we'll go right to the vote. All those in favor of dismissing for lack of probable cause, signify by saying aye.
Aye.
Any opposed? 4-0.
Thank you.
Thank you. Okay. We are done with the preliminary hearings.
All right.
We welcome back.
Welcome back. And you didn't bring the coffee.
Yeah, we're going
No.
Well, as late as it's getting, somebody's going to need some coffee.
Okay, the advisory opinions, item C is our next one. The first one is clarification of seats in terms of the Board of Ethics. This is what we have This is what we've discussed in multiple meetings about, when we last just talked about it, we were going to get all the, I felt like we had pretty much agreed to the substance of it all. We were just going to attach the exhibits that we had to come to be able to vote on this as our final. It's the advisory opinion number 2015-1. Again, this would establish our seats in terms, so that due to the lack of our records, both in the county, it was a question of where each of us sit in terms of seats, and this would establish where we currently sit and our expiration dates per se on this board, and so we can relay this to the county and the Board of Commissioners and and the CEO's office, so that when they're making selections, they know with certainty what seats they are at. If you guys would like to read, kind of flip through it one last time, I believe.
I read it today, so
Yeah.
I'll sit and wait.
Okay.
I read the whole thing.
But again, it sets out where our seats are at and where we go.
Well, I just had a couple of comments.
Okay.
On the second page,
Okay.
the first full paragraph, it says, "It is clear that the appointing authorities have departed from the requirements." And I know what we're saying here, but I'm a little, it's troubling to say that they departed, because it sounds like they affirmatively said, we're not going to do it like that, we're going to do it this way. And I think they more or less failed to follow than departed from. It ended up being a departure from, but you know. So I understand what it means, but if someone else reading it, after we're all gone, they would all be wondering what the commissioners did, what the CEO did. Why did they go wrong instead of just failing to follow? That was one thing. And then in the middle of the next paragraph, it starts with, well, actually it's the third sentence. For instance, the BOC appointed 2 members at the same time. And then the following sentence says, the board has no definitive record to determine which seats Ms. Greer and Ms. Nugent occupy. I thought that Thelma had something that said when her term expired.
She had stated that, but never provided any documentation of that, other than the county website.
Okay,
I think, I'll interject here, I think my remembrance is that she said that she had a document, a letter or something, and it said that she was serving till 2016, but I don't think that it identified if she was in seat 3 or seat 4.
okay. Just the term, okay.
Does that make sense?
Okay, so the statement says which seats, okay.
Yeah.
Well, those are my only comments. That sentence that said departed from, I think I saw it twice, but I know I saw it right that one time.
It's the next
It's in the
paragraph.
question.
Yeah, at the end of the day, I guess they did, because they didn't do anything, right? Would you say that? That they departed,
But yeah,
they
but
didn't
when
do
you
it?
say they departed from it, to me, it implies that they agreed that we're not doing that, we're gonna do it this way.
Oh.
And I don't think they did that, I think they just failed to follow the instructions. And, lawyers tend to speak specifically. And that's one of my, that's one of my,
Is there an objection to reframing that the way Clara has characterized it? I mean, I certainly don't object
I have no
to
objection.
adapting the language to failure to fulfill the requirements or whatever would do, however you would
But they
propose it.
did
But I see
fulfill
what
the
you're
requirement,
saying.
they just didn't get the date right.
Now, how are we gonna, if we do that,
Yes, I'm
and dealing with the
saying,
word
right.
depart,
Yeah.
how is that gonna affect the language when we get to the, starting from the paragraph we just discussed,
Right.
the next paragraph, it says neither CEO nor the BOC has the authority to depart. Now, are we changing that, or that word can remain?
Well, see, and that's, when I read that, I thought about that also, because that does imply that they affirmatively departed.
They did.
And, well, departed with intent to depart.
Oh.
So-
okay. Got it. That word intent might be,
Well-
but they definitely departed.
Yes, they did depart, but when we say they had no authority to depart, and they didn't, they probably should have. I don't know how we would say that. I think that could probably stay like it is.
I think you're right.
Okay, that one could stay as is. And I see the difference if we leave this one,
Yeah.
as opposed to changing the verbiage up top there. I can see where we would leave that one as is.
So you were
Okay.
thinking about on the first paragraph, it's clear that the appointing authorities have failed to follow.
Fail to adhere to the
Yeah,
requirements.
There you go.
And here would be better word.
Yeah, I guess so.
I think so.
From the requirements set forth above.
That's right.
Okay.
Adhere to.
Adhere to.
Here too.
Adhere to the requirements set forth
Here
above.
too.
Okay.
Depart. That's what we're saying.
Yeah,
Okay.
instead of have failed to adhere to the requirements set forth. So departed from is
Well, I was on the line
Yeah.
depart. I got you. Okay.
Clara, did you have any issue with the language on the first page under question presented? I believe that's where you saw it.
Front page.
That one doesn't play into it.
Yeah,
that one remains the same.
So,
But I think there should be an S on depart. Shouldn't it?
Offices depart.
Oh, when the board of commissioners depart. Okay.
Yeah, that's
Okay.
well, if that's, anyone else see any other issues that they see? We have, I take a motion for approval of this advisory opinion.
Move approval of this advisory opinion as amended by the discussion we just had.
Okay. Is there a second?
Second.
All those in favor of approving this advisory opinion?
Aye.
2015-1, signify by saying aye.
Aye.
Aye. Any opposed? Claire, do you vote yes?
Oh, yes.
Yes, unanimous. Okay.
Well, want to get your signature on here, Paul?
And I'll,
Third.
the next matter is Ray Johnson, request for advisory opinion about the Board of Ethics use of county employees.
All right.
Ray.
Let me ask you quick, I'm sorry.
Sure.
Do you want me to leave this page as it is, or do you want me to make that correction and insert a new page?
What do you got? I'd say.
See, make a correction and insert.
I'd like to do that.
Yeah.
Oh, yes.
Okay.
It's too
Okay.
much paper.
Yep. Okay.
Well, we down.
Mr. Johnson?
Ray
Do you want us to hear this case today?
Sure.
Okay.
Ray Johnson. Okay.
Okay, if you want to come on up.
You need a motion to take it off the table, too.
Oh, I do need a motion to take these off. These were tabled. Oh.
Need a motion, okay, I move that we consider the matters under items 2 and 3, under advisory opinions.
Is there a second?
Second.
All those in favor, signify by saying aye.
Aye.
All those opposed? Yes, unanimous. Okay, Mr. Johnson, they've been taken off the table. If you would kind of state what you're requesting you have two advisory opinions. They're very similar. For the board, we can hear both of them kind of at the same time, just for interest of time.
Well, I think both of them are self-explanatory. I guess we should do the staff conflict. Which one do we want to do first? You want to do the use of county employees? I think if you just issue an advisory opinion that will not occur again in the future. It has happened in the past, and I believe it's likely to occur again in the future, where there was a staff person used from the county attorney's office, which was a direct conflict of interest with the board. I think if you would kindly handle that and issue an advisory opinion, I think that would be satisfactory. The person is no longer serving, but it's likely to occur again in the future.
I thought we found a place in the code that said that the county was supposed to provide certain office equipment and assistance to the board.
22A, I-4.
Okay, you got it there? I was looking for it.
Okay, AI-4.
Do you want that read back or read to you?
Yeah, go ahead.
Yes.
The governing authority of DeKalb County shall provide adequate office space and meeting space for the Board of Ethics,
Right.
subject to budgetary procedures and requirements and DeKalb County Merit System regulations. The Board of Ethics shall be authorized to employ its own staff and clerical personnel. The governing authority of DeKalb County shall also provide the Board of Ethics with such supplies and equipment as may be reasonably necessary for it to carry out its duties and responsibilities. The Board of Ethics shall be a department of the county government and shall be subject to budgetary procedures or requirements in the same manner as other departments of the county government. Provided, however, in exercising its powers and duties under this section, the Board of Ethics shall be completely independent and shall not be subject to control or supervision by the chief executive, the commission, or any other officer, department, or agency of the county government.
I mean, I would say that, yes, it'd be best practices not to have county employees doing both, but we are subject to budgetary concerns. And at that time, when we had no budget,
That's right.
Whatever help that we had occurred, to keep us, to get us organized, in itself was not a violation of the Code of Ethics. But I'd like to hear from anyone else.
The use of county employees for the ethics board is almost not possible. Let me tell you why. Because for every time we use this room, we're connecting to a county employee.
No, but you already did use an employee. That's the point.
And that's it. I like what you're saying, past tense. So I'm speaking about future. You're wanting an advisory opinion to hold us to never ever using another county employee. For every time we book this room, we engage with a county employee. For every time we, correct me if I'm wrong, are you working along with a county employee when you solicit the use of this room?
I'm calling.
You have to call
That's a
it.
county employee.
No, she's hired by the board. She is not supposed to be working for the county.
She's not. I'm
Okay.
saying we will encounter interacting with county employees to do the job we're required to do.
No.
Is that not what you're?
And the code allows that. I don't know why we're.
Okay.
The board is supposed to be completely
Yeah, the code says we can't.
completely independent. You can't mix and match employees.
Okay.
Ray, we've heard what what you asked us to do. We're the ones who have to,
Okay.
to sit and discuss how we're going to handle this advisory opinion and what we want to say, based on what the code says and what we believe is in there. Susan, putting the glasses on.
Yeah.
That's your universal sign.
No,
Susan's about to.
Let's get it done right, okay?
No, I just was wondering, and about to ask Mr. Johnson a question, if that's okay. You know, if this board moves forward and hires additional staff, as we have contemplated doing, they end up being employees of the county. How is that distinct?
This is an independent board. You're using a budget that is independently distributed to you for the purpose of hiring your own staff. It's a conflict of interest if you have the secretary of the county attorney serving as your person recording your votes. And all I'm simply asking for is an advisory opinion that will not happen again. You have a budget, you have an over $200,000 budget, you did not use your budget last year. There's no reason why we should run into a conflict of interest situation, once again.
An advisory opinion is just that.
It is.
We can't give you an advisory, you can't tell us what the advisory opinion should say. And so you're coming to the county asking for an advisory opinion, but you're directing what you want it to say. And it doesn't quite work like that.
Well,
the opinion will be based on the code and what we're allowed to do under the code.
under the state law.
Under the code.
Under the state law.
Okay, well then.
SB 590.
At that point, then you should proceed with whatever you need to proceed with. But the advisory opinion will address the code. That's our purview here, is to address the code.
It's an opinion with respect to the board using county employees to conduct their business.
Absolutely. And it will be
That's all
based
I'm
on the
asking.
code.
That's all I'm asking.
Okay. And it'll be based on the code.
Okay, Claire, as I see it, it allows us, the counties provide the resources to let us run. And in the past, the county has not provided enough for us to hire our own staff. We are subject to budgetary constraints, and if the county does cut our budget again, I don't see how we can, if in the future, if we have cannot hire on our own, we cannot use a county employee to help us.
John, you cannot use them.
Ray, we're discussing amongst ourselves. Unless a question's asked you, please. So, I know that's kind of where I kind of feel like we're going. I agree, it's best practices to have our own employees, that we have a proper budget and such. But to bind the board, if all of a sudden the budget falls out and we get nothing, or a board in the future, when and that we can't have use someone to help us schedule meetings and be there to take our minutes. Kind of going along the lines of using the county attorney's office to maintain records, I think that's kind of something that was part parcel to our former.
Well, we're discussing one issue at a time. We're not taking them together. So let's discuss this.
We're discussing your advisory opinions, right? So, is there anything else you guys? How are you guys thinking? Because we need a direct, we do need a direct Gene to how we want to put this out.
Well, I just have one question. If we don't have any money and we need somebody, what are we supposed to do? Based on, you understand.
Well, you do not use county employees.
Listen, you see, you going back the same question. I'm asking you a direct question. If we do not have the money to do something, and we have to use somebody, who are we supposed to use?
You do not use a county employee.
Well, I can't get an answer out of that.
According to the state law you're operating under, you do not use a county employee. It's a conflict of interest. You're an independent board.
Okay. With no money.
It doesn't make any difference. You have no money before.
I got you. I hear you loud and clear.
You have $200,000 now.
That don't mean we're going to have $200,000 next year.
Not my problem.
Not mine either.
Okay, so where do you guys want to
Should I make a motion?
Yes, please.
Yeah, please make a
Go
motion.
by what you have there.
I move that we address the advisory opinions, based on the code.
Right. No problem here.
I mean, this is what we go by. So we base the opinion on the code.
Susan?
I just wonder, and Clara, let me just pose this back to you. I mean, I think the code, I mean, we're all referring to the code. I wonder if Mr. Johnson's question isn't more appropriately addressed in the legislature.
I think so.
It could be after he gets his
that-
advisory opinion.
So you think we should do an advisory opinion on this?
Because he
And,
asked for that. So
yeah,
we have to address that. And when we give him.
I mean, we could decline.
It's already clearly stated in SB 590 that it's an independent board and that the staff is to be hired by the board, not under the control of the CEO. That is my whole point, and that is where this board is headed.
So do you believe that we should decline and go?
Well, I think the question is, what does the code say? Do we
It
need
says-
further clarification, rhetorically, do we need further clarification about what the code says?
That's what
I
the
know,
opinion
but-
would
That's what the
Suggest.
opinion, all right.
That's what I read. I with Claire, that's what I read.
Okay.
I mean, if y'all want to get a legal opinion, that's fine.
Gene,
That's what we're gonna do.
Gene, what's your take on, in terms, I mean,
Well, an advisory opinion is designed to govern future conduct, and you can look at it in two different ways. One of them is it is a state law. I mean, the code is state law. And if there's any changes to be made to it, that should be a matter for the legislators. If you're just looking for an interpretation of it, then I think it's probably a proper matter for you to issue an advisory opinion interpreting that as applied to Mr. Johnson's questions. It really just is a matter of whether you want more clarity as a board. You've got a request from a citizen for more clarity, but it's upon you to decide whether you believe more clarity is needed.
Well, I just want to clarify.
Go ahead, Claire.
Said citizen is not seeking clarification. Said citizen is seeking a definitive promise that it will not happen again.
That's it.
So,
I would like to see it never happen again, but I know that we have pitfalls and things happen. And you have to make a decision when things happen, what you have to do. You do nothing or you do something.
You follow state law, and it's in the state law.
I got
That's
you.
simple.
See, I hear you first time, but I just know that.
Follow state law. Is that difficult?
Well, I don't think the board has to advise itself to follow state
I
law.
don't think so. Don't have to do it.
That's my thought.
I'm sorry, will you repeat that again?
I don't think that the board needs to issue an advisory opinion binding itself to follow state law.
Right.
The board is bound to follow state law.
Do you need to get a legal opinion?
I mean, that is up to, we are getting a legal opinion right now, and he's stating it, so,
I think he gets paid the big bucks for the legal opinion.
got big bucks.
I mean, how about this? How about we could say something along the lines of, not necessarily an advisory opinion, but just as a general statement, best practices is that we have our own independent hired board. But
Well, I think we need to stick to the script. He requested an advisory opinion on this issue. And I guess, us getting off page and start to talk about best practices sort of puts us in a different place. You know,
Okay.
because everyone may not agree that that's best practices.
Well,
So,
How would you articulate the advisory opinion?
I never did see that in here, Susan.
Are you looking for the code?
Yeah.
Okay, I've got it pulled up right here. It's 22A I4.
Oh, okay. I4.
See if I can find it. Again.
I like to keep life simple. I would cite directly to the code.
So that's, it seems to me, we're in a circle, you know, that we have the code, and Jean has just said we don't have to advise ourselves to follow the code, and so I guess that's the question there.
So the question is, he asked for the advisory opinion, and the problem with that is that he tells us how he wants it to come to him. So that's kind of where the disconnect is.
If I get the point, he's trying to dictate what we supposed to do.
Right. Exactly.
He wants to dictate the policy.
So I guess we probably need to ask Mr. Johnson if he wants an advisory opinion, or does he want us to tell him what he wants us to tell him?
That's what I'm getting.
So, and then we go from there.
at this point, we'd have an advisory opinion citing the code
Right.
and saying, here's the code to dictate the terms of the ethics board, which we already are under.
Right,
And in matters of hiring and firing, look at the code.
right.
No, but you know, I don't know how else to close out his request. He asked for an advisory opinion. We have to, either we give him one or we dismiss. I don't know how
Or
we get.
decline.
Yeah, we decline to.
And we can decline.
You can vote to issue an opinion, or you can vote to decline to issue an opinion.
Can I put a motion in on that one?
You always
Decline.
you can always make a motion.
Make a motion to decline.
Based on the fact that the requester wants the specific answer.
Give me a legal term, now, Mr. Attorney over there, on how we gonna decline this motion that you make. Make it legal for me, and I definitely.
She just gave it to you.
I think she did, right?
Yeah, she's legal.
Yeah, I got two lawyers here. I'm sitting between two. I'm just an old country boy from the country, so I don't know nothing. So I'm trying to get some legal activities.
Well, I mean,
from two lawyers here. Three.
I mean, I agree that, you know, it is a circle. I just don't know how we advise ourselves to advise on the code.
Advise yourself to advise, right?
Yeah. And I think if in the fact that if it came back up again and someone filed an ethics complaint and we denied that ethics complaint, then they would have a right to go to the Superior Court to say this is wrong.
Right.
And so, you know, there's a motion to decline issuing an advisory opinion on this matter. Is there a second?
I make the motion, somebody else.
Second.
There you go.
All those in favor of declining to issue advisory opinion on the use of a county employee, signify by saying aye. Aye. All those opposed? No.
And do you want to add in the language that Clara used?
Yes.
And tell us again what that was.
Excuse me, would you like to add best practices to the letter that you sent me?
I think we're going to go with Clara, what was your language?
Motion to decline based on the fact that the citizen requested a definitive answer notwithstanding the code.
Yeah, I'm sorry, Claire. Looking for something else.
Yeah.
I think Jean's
You're
ready.
good. Okay.
You got it?
Okay, Mr. Johnson, we have the use of county attorney's offices for maintaining of records. We did not discuss it, we kind of were discussing a little bit, but we're taking each individually. So I believe we're going to go kind of down the same route, but you please go ahead.
Okay, here's what the law says. Furthermore, the rules and procedures of the DeKalb County Ethics Board 2.1 provides that the official copy of all records of the board shall be maintained by the clerk of the governing authority, which is the county clerk, who at this point is Barbara Sanders. Every document that you produce must be filed with the county clerk. And whenever you get to the fraudulent opinion number 15, when you get to that issue, you're going to find out that the documents were not properly filed by a previous board with the county clerk. And you're going to find that that's going to be a problem. It's probably going to result in a lawsuit. And going forward, I would suggest that every document be filed with the county clerk. I have filed open records requests, and you have not done that. I can verify that. And I would appreciate it if you would issue an advisory opinion that you will be doing that in the future in compliance with state law, once again.
Okay. Susan?
I was just about to look at his request again. I thought it had to do with not using county offices.
I thought so too. You just said it. Now you're going back to county office, right?
Do we have a copy of his request?
I hear very
I know
well.
I've got a copy of this here. I was about to look for it, but it will take me a minute.
Take it somewhere. I have one in my bag there someplace. If you have it, don't have to go for
I
my
know,
bag.
I've got it.
One thing I listen very well.
Johnson, do you have your complaint? Okay, he's got a copy of his complaint right here. Okay.
Okay. Okay, if you guys don't have it down here, I'll read it real quick.
Read it out loud.
Okay, the state, the DeKalb County Ethics is currently maintaining files and records of the county attorney's office which violate 22A I-4 of the county code of ethics. See attached addendum.
Right, so that is the subject, and it is not what Mr. Johnson just said about
It's using,
the procedures related to submission to the county clerk.
correct.
So if we go back to,
There's the state law.
Okay. So that's the I-4, I believe, right?
so this is an addendum. And when was this one filed? I'm just trying
That
to
is
make
the
sure, Mr.
state,
Johnson.
that is the quote from the state law, SB
Right.
590.
Right.
That requires you to keep the records, all of your records, with the county clerk.
Sure.
None of your records are official until you file them with the county clerk. None of these records are official until you file them with the county clerk, and you're going to find that whenever you get to this fraudulent opinion number 15, some attorney is going to point out to you that none of your records are legal until you file them with the county clerk. All you have to do is email all this stuff over there when you finish a meeting, and you have a person hired to do that.
Okay. I think all of us are keenly aware that our documents have to be filed with the county clerk, and that is what provides the authenticity to those documents.
Yes, it is.
Okay, so
That's what makes them legal and makes them so you can take them to court.
Okay. Secondly, since you have mentioned the fraudulent, number 15 or something, what you've just said, that's not the subject of this particular thing.
No, it's not,
And I
but you're
would
going to
suggest
run into
you-
that problem.
I would further suggest to you that if it is a fraudulent one, as you so allege, that it would not be in the county clerk's office. So that's point number 2.
No,
Point number 3, Mr. Johnson,
but it
is
would have
that
been,
what we're-
it would have been filed originally.
Robert, Ray, sorry, Robert.
It's all right.
All I'm
trying
If
to-
it were filed, it would not have been able to be
Ray.
forged.
I'm
Ray,
quiet. I'm just listening.
Susan.
You
That's my point.
understand?
All right, now point number 3 is I am simply trying to make sure that we have the parameters of your current complaint, the parameters of what is on our agenda tonight, and not an addendum that may or may not be on the agenda. I'm trying to find out if the addendum is what's on our agenda tonight.
That
In
was
terms of-
filed with your records, if you have your records. It was filed with it.
It was filed with
Yes, it
this?
was filed with it.
Okay,
If you've done your homework, it was filed with it.
all right. Okay, but your complaint says that you're concerned that we are maintaining records at the county attorney's office. That is the complaint that you have.
This is over 6 months old. You were maintaining records at the county attorney's office, and you were supposed to be filing them with the county clerk.
But this is advisory opinion, so it's stuff going forward.
Right.
And, there's a long list of reasons.
Do I need to file another ethics complaint?
You, of course, can do what you want, Ray, which you will do. Again, we get back to the same question as last time, which is, the code says this to do something. He's asking us to do what the code says. We're doing what the code says. If we were not doing what the
You're
code
not
says,
doing what the code says.
Ray, stop it.
Chill out, man. Chill out.
We're trying to get through this, Ray. We worked diligent and hard to get this board working, to someone to your liking. But you keep on coming up to us, yelling at us, and getting in our faces does not help matters. It does not help your matter. It doesn't help our matters. We will go through this. We are trying to do what is
Just
best.
calm down.
No, you calm down. You calm down.
Come on, maintain a sense of humor about it.
Anyone have a pocket mirror?
So again, I believe we are going to get back to the same situation. And the last thing, which is the code tells us to maintain the records. That is what we're doing. We are no longer using the county employee. I was not aware of us maintaining records there, other than the county employee in their business would get emails and such. That all records were being forwarded to the clerk. Any records that are not being forwarded to the clerk, we post haste will get to them to the clerk. Again, it gets us to a circular argument, and where I don't see how we can issue an advisory opinion, because the code is clear that we are to submit it to the county to the clerk. So I'll take a motion.
Yeah, one motion that we
Decline
decline.
to issue an advisory opinion.
Is
Is there a second on that?
You got a motion?
Okay, all those in favor of declining to issue advisory opinion due to the fact that we, it is would be restatement of the code section. Is that?
You get a vote?
Oh, yeah. All those in favor say aye. Aye. As opposed?
Okay, just for the public record, you do not intend to follow the law.
Okay.
So, I'm going to have to take some other action.
Status reports.
Please, do whatever you gotta do, man.
Status reports, pending matters. Again, these are all the cases that are tabled or in preliminary investigations. I have, I believe that a couple of them are very close to coming out of investigation stages and would be on our next meeting.
Go in D.
We're in D.
Okay.
The Sutton cases and the Brownwood cases look like, and maybe even the Watson case could come out the next meeting, depending on where we're at. Any other? Obviously, there's one I can't comment on, and I'll step off. And if there's
Any comment about Lunston complaint against John Ernst?
I just saw your email a little bit ago.
Is John Exton in the house? He's not here, right?
Yes.
Oh, here, he's back there somewhere, right? Okay. I just want to know was you in the house. I didn't see you. Apologize for you. You're big enough. I should see you, right? Okay. Stand up and blow your head or something. Right? But the complaint when it was made against John, his name was never mentioned. I went back and read it, and I saw that film on television that they had that you was telling me to see. I made sure I saw it. Your name never came up in his interview. So how did it become you? I don't get that.
Who's the acting chair?
I just asked you a question. You know, your name never came up. If I write it, your name never came up, right?
Well, I know, but
I'm just asking a question.
I don't know. I have yet to see.
This was on your agenda to be tabled and not to be discussed
Right.
as far as this, right? And this is the same argument he brought up last time when he hadn't viewed the videotape in its entirety. And my name does come up in the interview as stated by the reporter to the conversation with Mr. Ernst. And if we're going to have this conversation now, okay,
I think we're not going to have it. It's not
No,
the time
then-
to have it. We're
I
not
was just a
prepared to
question
have it.
because I didn't
And
see
so
your name.
Sir.
The question is improper.
you've demonstrated from the beginning that you have a feeling about this before the case even started.
Well, I asked you a question before, and you
I know,
took an
but
attitude
Robert,
then, so I'm
Robert.
asking another question. It's fine, I'm through with it.
Okay.
I'm done. Okay, I'm done, I'm
Okay,
done.
it's
Did you
out of
call
order.
me slick last meeting? Yes, you did, you lied.
Lord have mercy. Lord have mercy. If you come outside, I call you.
Oh, no, 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 no.
That's where you want to
No,
go?
no, no, Robert.
But we'll do it outside.
No,
I don't call people names.
no.
I don't do that. I'll just ask a question. Thank you, God bless you. See, out there, you won't be the ethics board. Right. Go ahead. No, I'm back to you again.
We should probably, because I haven't had a chance to think about this. Are we going to put this in a preliminary investigation stage? And so if we are, I think that it's proper to have independent investigators and go from there.
Yes.
I'll take that direction.
Okay.
It's back over to you.
Okay.
Okay.
Robert. Robert.
Yeah.
Yeah, Robert, you know, we do have to worry about commercial with this, which we come out, okay?
Well, but the
I know,
guy
I know,
can't
I know.
insult me and think
And
it's all right.
Robert,
It don't work like that.
Robert,
Go ahead. I'm
Robert.
done with it. I'm done with it. Don't insult me. That's all.
Okay, new complaints, new business, new complaints, to determine jurisdiction. We have the Sharon Barnes Sutton versus by Viola Davis, amendments to complaints, and the Judy Brownlee by Viola Davis, amendments to complaints. I believe, Gene, that these were amendments to,
Ms. Davis filed these on forms as new complaints. It's really up to the board of whether you want to direct me to treat them as new complaints or amendments to the complaints that she already has pending. I'm sure that you've read through the information, and there's no new information that is jumps out at me, and I'll defer to the board members. But if you could treat these as amendments to the complaints, send the complaints to the investigator that's handling those complaints.
I think it would make sense for us to attach it to the previous complaint if Ms. Davis is agreeable to that. And then it seems that the complaints would benefit by some specificity. We ask that our complaints have a specific citation about the prohibited behavior, and in the amendment that you are proposing, I don't believe it shows a specific. So if you were okay with that, it seems to me that it would make some sense to attach it to the earlier complaint, and then perhaps in the next few days do some specific citations. Is that okay? And Mr. Chair, do you
Yeah.
want to hear from Ms. Davis?
yeah, I'll hear from Ms. Davis.
I just wanted to update you that due to the length of time that has passed, if you go back, if you like, I did attach all the different ordinances, the state law, the organizational act, anything, all the different ones you wanted me to specify which law, I went back, copied it, attached it in the form. All of that is in there. If you would like for me to resubmit it, I'd be more than happy.
Would that create a hardship for you to do that?
Well,
Is that necessary?
yeah.
I wouldn't want to.
I mean, I scanned it all in. What I can do is...
Yeah, you have provided an extraordinary level of material. I guess what I was to assist this board in properly evaluating your complaint. It is important to know the specific prohibited behavior. And the language in the code is expansive, but we do have 9, 10, or 11 prohibited behaviors. And if you could sort of attach each of your allegations to that prohibited behavior. Gina, I know you have recently looked at that too.
Right.
Is that good direction, or do we need to be more?
Well, to the members of the board and Ms. Davis, in her executive summary, the first bullet point cites or quotes the informing paragraph
Right.
to our Code of Ethics. It doesn't cite any one of the paragraphs that with specific prohibited conduct.
Right.
So there's really no, I mean, it's, again, it's a,
I'm sorry, which one did you say?
this is the one that you filed, I believe it's January the 9th, 2015. So that's what I read in here. If Ms. Davis wants to provide clarification with regard to specific prohibited acts and specific acts of conduct that violate those paragraphs. Otherwise, you're again asking an investigator to basically dive in the lake and try to find something.
Yeah, Ms. Davis?
With all due respect, I would like another term. I will go back and I will show the specific copies of the pages. I'll do all that, and I will show you where I presented that information the first time. I will date it, then I'll go back and show you again that I sent all that to you. Partly because I was answering Ms. Barnes-Sutton's initial reply from her attorney, just to show you, because that's one of the concerns he brought up, that I did not specify what part of the code. So I went back and made the copies. So what I need to do is get it to you and then show you where I presented it the first time, what date I presented it, and then send it again. And that way it can be a little more helpful.
So should we table this, or should we?
With Ms. Davis's consent, you could consider this as an amendment to
Right.
the pending
Yeah.
complaint, if that's
Right.
agreeable to her.
Is that, are you agreeable to that this is an amendment to the complaint? And
I
we
mean,
just,
if it can simplify things. I said new because it may have deflected from talking about P cards or something like that. It was a new subject matter. I didn't know if that would have to be classified as a new complaint or if it would be classified as a amendment. I was going to leave that up to you to decide. But if you will instruct me what is more helpful to you, then I'll be more than happy to present it that way. Because I did give you a lot of documentation. I'm sorry.
Yes, sure did.
yeah. So, I mean, I think,
If I could ask a
Go.
question, to be perfectly clear, when one is filing an ethics complaint, Jean, if you're looking at the code now, would one not need to cite 22A C 1 through 7, 1 through 7?
Correct.
One of those.
Correct.
So 22A C 1 through 7 to each of your allegations. And, but 22AC 1, 22AC 2, yeah. So it's 1 through 7. Those are the prohibited behaviors.
You say 22-7.
22A, C, 1 through 7. Those are the prohibited behaviors. And so what I think I am hearing from Ms. Davis is that she would not object to
Moving this to
moving this to the
original.
right.
Okay, I think there's consent. Is there any disagreement on the board? Barring none, it's consented, move these to the original 7 and 8. These 6, sorry, 6,
7 and 8.
no, I'm sorry, 6 and 7.
6 and 7?
Yeah. Okay, the next, and that was both the Sharon Barnes' son and Judy Branley, correct? Yes, okay. Next matter is C against Jeff Rader by Barbara M. Lee. And I believe, so Jean, tell us about this case
Okay.
for preliminary.
Dr.
And
Yep, recusing.
Okay.
recuse on that?
Okay.
All right.
Make sure you know that she recused.
All right. For Commissioner Rader, Dr. Lee, on behalf of the Coalition of District 5 citizens, she alleges that Commissioner Rader is not following the posted mission statement of the commission, which is to improve the quality of life for the stakeholders of DeKalb County through governance, representation, and accountability. And in essence, the commissioners have voted no to appoint somebody to represent District 5. So Dr. Lee is alleging that this is unlawful. She alleges an alliance between commissioners, which is constituting the ineffective government or no government. So, as far as subject matter jurisdiction, personal jurisdiction is there. Subject matter jurisdiction, I don't believe is there, because if there's nothing in here that violates, the facts don't give you sufficient basis to say that he's given a reasonable basis for the impression that the member may be improperly influenced in the performance of his or her official duties. That's my take.
Okay. Well, while I believe, this is, District 5 needs representation, I believe that this is a political question, not for us to decide. There's a, state law that they're working through. It's very unfortunate that this is as messy as it is, but this is of a political nature, and is not something that's governed by the ethics code. I don't believe we have subject matter jurisdiction the way I read it. Clara?
Well, I'm actually going to recuse myself from these three because I live in District 5 and I have a dog in the fight, basically.
I have a big dog in the fight, so I guess I have to accuse myself from it too. But this dog is big, and this dog is still growing. So I'm going to accuse myself from it also.
Okay, so if we have all District 5 members who are recusing themselves, we have Miss Susan Nugent, who's recused herself from Jeff Rader. We're left with 2 members. There's not enough members here to vote. It fails for a lack of ability to determine lack of quorum. And if that's the case, if come back in.
Yeah.
Gannon and Jester are going to
Jester and Gannon are identical complaints.
Same complaint, and I have the same problem with all three.
But I do want to say this, and having recused myself, I think that we do have 2 members missing, and I think this is a big issue.
It's a serious issue.
And I think that we should probably table it until the next meeting. I don't think it's right.
Well,
to dismiss it tonight.
actually, on this one, on Gannon and Jester, there are 3 members. So there's,
Same complaint.
that's a quorum, so you're right.
Yeah, so, whatever decision you're gonna make, I think that it should be properly voted on, not fail for lack of a quorum.
Well, there's that case if there's like a
If
quorum, we
you have a lack of quorum, you
can't do anything. You're right.
it goes to the next meeting.
Okay.
So the whole thing goes to the next meeting.
Yep.
All right, that's what I want to say.
Okay, so items C, D, and E will all float to the next meeting due to the lack of quorum.
Was that a request for an advisory opinion, or was it a complaint?
A complaint.
Does it comply? Do we need to advise the people to ask them to specify which?
It advised. It did.
Okay, they gave a
Yeah,
citation.
a citation, yeah. For
Which one did they use?
undoing
They used
influence.
the first one, so it'd be C41 or C48. Give a reasonable basis for the impression that the member may be improperly influenced in the performance of his or her official duties. My comment was that the recitation of facts may not cause these allegations to be within the jurisdiction of the Code of Ethics, the subject matter jurisdiction.
That was my question, sort of, and I think it would be useful to the body if we were clear about how it is a violation of the Code of Ethics. I think that would be a constructive,
But we do lack quorum.
If it was up for discussion, I'd be happy to discuss it.
No.
No, I'm just asking.
That's a serious problem.
We're lack quorum. If we lack quorum, unfortunately,
You can't discuss it.
you can't move forward. We can't do anything. So, the next is request for new advisory opinion. We just put it on. Ms. Davis, you had requested new advisory opinion about conflict of interest. We'll take that up in the next meeting, but wanted to get up there. Now we're on a board governance. Again, the resolution on purported fraudulent opinion. As we all are aware of the news reports that a purported advisory opinion number 15 has been circulating in county records, not in the clerk's office. The former chair of this board has indicated that he did not sign that opinion, and we have a possibility that there's a fraudulently signed ethics board opinion. I take this with the utmost sincerity that this is a violation of obviously possibly of law, but of the integrity of the ethics board. I am asking this board to adopt a resolution. This resolution would basically number one would waive our attorney-client privilege with our former attorney. I know that that outside organizations of investigative nature of police, both in federal and state and local, are looking into this matter. I believe that there are to be subpoenas and stuff that are going to be issued on board members at that time to figure out exactly how this complaint got in the hands of where it was. I believe we need to waive our attorney-client privilege with Steve Irving on this matter so that there's no holdup in that in the case of where these things are requested and he will not have, that he could freely give these, any documents he may have to the authorities. Gene, do you want to?
Well, did you pass out?
No, I haven't. Sorry.
The chair asked me to draft a proposed resolution for your consideration, and I've done so. It is a draft, so if you want changes in there, or if, and it's up to you.
Excuse me, I'd like to hear the proceedings. Would you please not bother me?
It's up to the board, A, whether you want to issue a resolution, B, and if you want this resolution, if this one is acceptable to you, or if you want to make changes to it.
But I take this with the, most extreme gravity and seriousness. I believe that we need to, move forward with this so that there's no question that whatever occurred should be found out.
Yeah, but how can we find it out? I mean, what we have to do?
Well,
Prosecutor's office or something?
This thing waives our attorney-client privilege with Steve Irving, so that when they request documents from him, that he would be free to give those without having to worry about his attorney-client.
Now, what is the purpose of the resolution?
Well, we under this, we resolve the Board of Ethics waives any attorney-client privilege it may have with Steve Irving, former counsel, incurring the investigation of this matter, and provide all documents and information it possesses, and utilizes all resources and assist with any investigation by law enforcement to discover the truth about this matter and bring the persons or persons responsible to justice.
I guess I'm just one person, but I don't see why we need to interject ourselves into this with a resolution. This happened with the previous board and the previous board attorney, and has anyone asked us to do a diligent search of our records? Because we don't even have all the records, because Steve was holding on to them.
Yeah, and I saw that email from me. He just after our complaint had been filed and such, he just as of Tuesday of last week, Monday, delivered a box of documents.
Exactly, because he wants out. Yeah.
And we have scanned that box of documents fully. My assistant finished that today, and we will. I was meaning to bring us a thumbnail drive, which I'll give over to our attorney to then get over to the clerk's office, whatever we have to organize it to then get over to the clerk office. But I've been contacted by numerous law enforcement agencies.
And Clara, I do want to let you know that over the past several months, I've been contacting former members of the board to see if they have any records. So that's kind of where that comes from, a diligent search and a reasonable search. So I've been asking people if they have records that.
And we're as Edwin and I came on, when we talked about, one of the first things, like where our records were at. This is going on this to try to get all our records that we have. So.
And that that all makes sense from that standpoint. But I guess what I'm saying is that, that's a huge, ugly issue, and we're not involved. I don't see why we want to jump in there.
I think all we're doing at this point is officially waiving our attorney-client privilege with Mr. Irving, and so that
do we have an attorney-client privilege with him?
We did at that point. He was our attorney.
2010.
But we weren't on the board.
Well, some of us were.
You were there?
Some of you were on the
Thelma and I.
Okay.
And Bobby.
And Bobby.
Okay.
We're all on the board at that time.
Yeah.
And Isaac has recently left the board. He was there. Terry recently left the board.
So just
She
like
was
if
there.
they have any if they want anything from Isaac, they will approach him individually.
No.
You know, like I said, I'm just one person, but I don't see the point in this as a resolution. I don't see the point in this board, you know, carting ourselves over and jumping into that fray. And I do understand now that there were members who were there, but they will contact you guys individually. They won't come to the board because I know nothing.
I know zero.
And I don't even want to know anything. You know, I don't want to be.
I didn't even know you had
Sometimes
a
this
board
thing
in
can turn into a
2010.
circus, and I don't think we need to join the circus.
Well, I
that's
guess,
just my opinion.
Susan.
I just say that, you know, the three of us who are on the board today were on the board at that time.
Mm-hmm.
And I suspect that any good attorney who has represented a client would say that they are bound by privilege at that point, and they would decline participation with any investigation. And for my part, I don't want him to decline participation. I want him to cooperate just as completely as he can with any investigation. This is not involving us in the investigation. We are not going to be doing it, but we are freeing him.
So do we need a resolution though to waive the attorney-client privilege?
I don't know that we need a resolution, but we need some action. We would need action, and this is an action. It wouldn't have to be a resolution, I wouldn't expect, but.
Well, we need a vote, we need to have something of documentation of it, and, you know, I think, you know, it is a resolution to accomplish that goal.
One question.
Yeah.
Are you asking that we on the board as of now free this attorney, which I do not know, the right to all privileges dealing with the board? That's what you're asking?
Asking to, we waive our attorney-client privilege
With him?
with him.
With regard to the,
Yeah, this particular document we have.
this particular supposedly fraudulent,
Fraudulent document.
document. I
So
don't
that
think
means that'll clear us up for having to deal with it under any circumstances, that's what you're saying?
Not necessarily, no, that's not what they're saying.
That's what I'm
not they're
asking,
saying.
because I know nothing about it.
It would not, it would not clear us up. It would not clear up certain individuals that served on the board at this time.
Oh, yeah, I'm talking about
But
guys like myself who
You're
know nothing
no,
about what we're
yeah,
talking about.
so they would have no reason
Right,
to
that's
talk
right.
with you.
Right.
My question to Jean is, in lieu of the resolution, is there something that the members of the board that was on the board at that time could create on a joint effort that would release any attorney-client privilege? Because again, I'm concurring with Claire that we all were a part of it. So a resolution here speaks as a board being involved with, every board member being involved with this currently, whereas some of us, it's obvious that some of us were not on the board 2010.
Well,
So could there be a document that would free up those board members that served at the time of the fraudulent case, and in fact identify those individuals to cover
well,
the attorney-client privilege?
my thought is that Mr. Irving was counsel to the board. He wasn't counsel to the individual members. So this board can waive any privilege if there was one with regard to this matter.
Okay.
You can do it through this resolution. You can just put it on the record, take a vote to say we waive the board's privilege, attorney-client privilege with Mr. Steve Irving regarding this matter. You could do it that way, and that's
That's probably gonna work, right?
I mean, we have the resolution here. it makes it all, the way I wanted a resolution so that it was laid out exactly, that everything's out there and encourage it, and it's not just a count, and it's we're voting on actual language that is then would be submitted to him and to any anyone official. When we make a motion and we do it, we're making a resolution. It's the same thing. It's just formal language.
One thing says the board. The board does not have any records indicating that it submitted a final advisory opinion regarding Mr. Irons' request. No one ever said this board did. They clearly talked about the board that existed at the time. So that's why I said this board is interjecting itself into the previous board's confusion. This says that the board recognizes the possibility that someone falsified a draft. I think we may be stepping out too far. We may be getting outside of this board's lane with all of this. I just don't see why we need to interject ourselves. I agree that we do need to waive the attorney-client privilege as it relates to the board that existed at that time and any members who are still here on this board. But anything other than that is, to me, getting outside of this board's lane and going back and hooking up with that previous board that no longer exists.
Well, I agree. We do not, we are a complete, we have 3 former current members, former members at the time, but we are having, we have now gotten money. We are now operating in an efficient manner. We're now submitting all that stuff. But this is just, again, a resolution to tell the world we're waiving our client privilege. This is
So why can't we just tell the world that?
We're doing it in this, and that this is a very serious matter, and it should be properly investigated.
And they're doing that.
And
all we're saying is that we're okay with the second suggestion that Gene made, that we are waiving any client privilege with Attorney Stephen Irving.
I agree with that.
So we could, why don't we just then, if you want to do that, we can cut out, again, this was the first draft. We could just basically, whereas the board recognizes the possibility of falsified draft advisory opinion, just basically the last 2 sentences.
Why do we need a resolution? Why can't we just issue a statement? What is your fixation on resolution?
What's your fixation? It's the same. We're doing the same thing. We need language.
Well, we don't need. Okay.
We need language to withdraw.
Gene,
Gene, can you hold on?
I'm
Let me ask you.
right.
Hold on. I'll ask you, Gene. What do we need to waive? What would we need to waive our attorney?
You can simply, the simplest way is to, for someone to make a motion, second, and vote that you waive the attorney-client privilege with Stephen Irving with regard to this particular matter. And when that vote is recorded in the minutes, that is the waiver.
Okay.
So moved.
Okay. So is there, we
I need to second that?
Well, it has to be a motion.
Okay, can you do that?
So moved.
Motion, second, we got it.
Okay.
Okay, I second.
Okay. There's a
Now
motion
we take a vote.
there's a motion to waive our attorney-client privilege with Steve Irving, former counsel of the board. All those in favor of said, please by say aye. Aye. Any opposed? 0. Okay. Next is the discussion of office and personnel to the aid of the Board of Ethics. And at this time, I think,
I think just to be really specific, when we reduce the language to the motion, we fail to be precise about the matter pursuant, anyway, to Mr. Vaughn Irons. And so I wish I had jumped in before we did that, and if we need to, I guess we can
Jean
change
said
it.
to this specific matter.
No, but that's not the motion was, she's kind of right in that regard.
I
Motion,
just think we need to insert in your motion, Clara, the specific reference to that alleged advisory.
Yeah, I
And
agree.
put the name in there, so that we're not waiving
Like Mr.
privilege
Iron.
on every matter that Stephen Irving ever.
Right.
okay, yeah, I guess if there's a motion to amend as such,
The previous
motion, yeah.
Yes,
So
yes, the
moved.
motion, okay.
Motion second. Okay.
Okay.
Wait a second. I need the language that you guys are motioning to, you just calling out.
Okay, I wish to amend the previous motion by inserting the specific reference to the advisory opinion reportedly issued by the Board of Ethics pursuant to a request by Mr. Von Irons. And that is the matter on which we are waiving attorney-client privilege.
Is it second?
And
Clara made it.
Clara had made a
Robert was second.
seconded.
Okay.
It doesn't matter, she second.
Hang on. The original motion, Clara made it, Edwin seconded it. The amendment, Susan is making it. Who's second?
Robert is.
Robert. Okay.
All right.
All those in favor, signify by saying aye.
Aye.
Any opposed? No. Yes.
All right, thank you.
Thank you, Susan. Okay.
I wash my hands, that's it.
Okay, a discussion of office and personnel to aid the Board of Ethics. Clara, this is gonna be talking about.
Okay, here's the confusion on my part. The position is gonna be announced again, is that correct?
Say that again?
The position is going to be announced again.
Well, if we hire an executive search firm, they'll take all candidates that are out and then look for any new candidates and then bring us the, top 3 to 5 candidates for us to interview. So there's not gonna be a reissuing of it. It's my understanding of how that's gonna work. There might be an actual. Okay. Last year, folks, as you remember, we voted to ask for a request of RFP, RFQ for executive search firm. We got that out. We received 3 bids. On there, I did forward all those to everyone. I did make copies of every of these. Do you guys bring them with you, or?
Yeah, I just have to find one, so.
Okay, you're fine. I have extra copies, so.
Well, I'll just take one of yours, and I'll have to look in my bag here. Need another one?
Okay, then there's that sample. God, there's lots of different samples. That one, that's that to her. For the record.
Can you tell us what we're supposed to have at the end of this?
Yeah.
I thought you had condensed that somehow.
Well, I
I
made
see
it.
that you were handing out exactly everything else that I had.
Yep.
I thought that you would have.
I have
No.
one bag full of
I did front and back cover, so it's less paper.
Nice. I
Did it all. Did it all.
And stapled it. So what we have here is basically 3 documents from the Robinson Consulting Services. We have one from the Royster Group, and then we have, I believe, I guess I passed them all out accidentally. We had, I think, 2 or 3 documents from the Browning group.
You short of one?
Why don't we go through, because some of these are somewhat confusing, let's go through and decide which of the things that you just counted out go with each of these.
Yep.
And then determine where the meat of the proposals are, because
Correct.
that was,
There
they're
are,
somewhat obscure.
yes, they are. The Royster Group is this one standalone document.
Okay, I'll use yours. I'll use
Okay.
one of
All right, that's all we've got in yours.
And it's all concise down to that.
Okay.
Then we have 3 documents from RCS, Executive Summary, Statement of Need, and an Acknowledgement.
Okay,
Then we had a, from the Browning, I'm not pronouncing, or from the Browning, we had a sample guide for ethics officer. We had a, the BSS group, and then the BS group successful, and this one. Yep.
this,
And-
and I think I'm missing,
DSS group right here.
the one that has 3 columns.
Okay, this successful search. Here you go. Here you go. There's another copy. I apologize.
I didn't get that.
You didn't get that one either?
No, I didn't make it down.
Okay.
The Royal Group,
Okay.
executive.
So we have a total of 8 packets. No, 7 packets. Okay. The meat of this, the Royce is in terms of actual numbers, is the Royster Group initially has, excluding expenses, is a flat fee of $40,000. The BSS Group is a quote of $36,000, and the RSC quote is $30,000. Those are the, on the terms of actual numbers, those are the quotes. Now, the after quotes, you go to who's done this job before, or experience. You have the BSS Group, which has given its, if you look through their documentation, has given times where they've hired ethics people in corporations, and ethics officers and ethics directors in search. The RCS Group, I've looked through myself, and I could have been, has a whole bunch of their resumes, but I didn't see anything where they had described anything that was ethics or of background. It seems a lot of it was marketing and other things from what my readings of it.
We're on, which one you're on now?
The RCS.
Okay, I'll follow you.
Okay.
I'll follow you.
The Royster Group, let's see, I am looking for, they don't lie out any that I see any necessary ethics managers or kind of experience. The Royster Group also just completed the Development Authority search for their director. And if you look at the references on there, that may cause an issue. Just talking about waste review.
Yeah, I see, prepared.
What's that?
That's waste review. And
Third page.
and
Okay. Okay,
so
that's the Royster.
that's the Royster Group. For me, it comes down to then RCS and BSS.
RCS and BSS.
The and one was a quote of 30,000. One was a quote of 36,000. Since money is not our sole determination, after we decide if we go on one firm, we could, individually allow for. We're not beholden to that exact number. In my, reading through these proposals, one has had experience in exactly our kind of matter, and one doesn't.
What's the RCS?
The DSS group has experience.
So DSS is more executive search, and RCS is more straight HR.
Yeah.
Is the way I had looked at that as well, just to add that in. Mr. Chair, what are we looking at now?
Okay, so, that's, we have all these proposals, basically, we'd be looking at to determining what firm we would want to go with, and making a motion to hire a firm, and if we so choose, and in contract to get the ball rolling.
Who provided the sample guide for ethics officer roles?
That was BSS.
BSS,
Yes.
okay. That's important.
And if you look through it's basically, I believe it's taken, now I can't be for sure, but it looks like it's taken from his previous searches doing the ethics compliance director type work.
Okay.
And, Mr. Browning was the man